Hi, I'm Andile Khumalo, and you're watching Entrepreneurs Stay Alive, brought to you by I'm an Entrepreneur. So the lockdown of the country has meant that, as we all know, anything that's got gatherings, anything that in fact requires you to leave your house, you can't do. And that has also meant that all sorts of people are affected in their businesses, but also as individuals who supply into the value chain of the eventing, staging, etc. environment. Katlego Malatji is the director at Tailormade Law, and he's also a man who focuses on the entertainment side. He represents many a musician, many a performer, many an artist, and many a freelancer. And we're going to talk about the legalities now. Mr. Malatji, are you well, sir?
I'm well, and yourself, sir?
I cannot complain other than, of course, the tough world we live in, but that's why we're here. We're all trying to stay alive, yeah?
100%, and survive we will.
Let's talk about liability. So you represent a lot of people that are suppliers into, let's call it, the eventing or staging environment. Somebody cancels the event on the basis of COVID-19. Can anybody recover damages?
It's really dependent on how your contracts are set up and really who's making the claim, for argument's sake. So you would deal, if we're looking at eventing side, with your service providers, the guys that would have brought your stage and whatnot next. The event is not happening. There's no service provided. There is no legal entitlement to claim, damages for the service that you did not provide. Artists' contracts are set up very differently, where they would then, take a 50% or 100% upfront. And they too, still need to provide the actual service of performing at the event. But it's on how the contracts are structured that determines a liability to pay back or not to pay back or to claim damages. So if I am hosting an event and I've booked you to come and perform there, and I've paid you, the event is no longer happening, but your contract tells me that there's a 50% non-refundable deposit to be paid, then it's immaterial what the conditions are. What you do find, though, in these situations, there's a lot of people who have not signed agreements. And where those agreements have not been signed, you would then fall on the common law position, which is most likely to return everybody to the position that they were at before they got into that agreement.
Does someone have to tell me that the event is cancelled? I mean, we all know the country's in lockdown. So let's say I did get booked for an event. I signed an agreement, and that agreement said that you will pay me 100% of my money, and nobody talks to me. I just keep the money, knowing full well that I had an obligation to perform, or am I required to actually pitch up? But I can't really, because the country's under lockdown.
The only way to rebut or refute the claim would be to actually pitch up and perform. And if you do not pitch up and perform, then you cannot refute or rebut the claim. But what would be needed from the other party is that they would need to notify you of the fact that they then intend to cancel or suspend or postpone whatever agreement.
So what does this teach us for the future? If I am indeed somebody that runs my business as a supplier to businesses or opportunities, and how I make my income is on the basis of events happening, what should I have as a standard in my agreements to make sure that I don't catch the short end of the stick here if something like this happens?
So I think what's very important is that people need to have contracts in place. And I'll tell you why. So people that are hosting events, they would have incurred a lot of costs prior to actually hosting the event. So booking out venues, paying deposits, and all those kind of things. Now, what happens is, if you do not have your contracts in place, you are in a very difficult position. So guys should be looking at contracts that have clauses which preempt situations.
Got you.
The problem is people don't preempt certain things. And you spoke about force majeure earlier. It's also the definition of a force majeure. When certain contracts, people would then break down and explain to you definitively what constitutes and what does not constitute an act of God. So in our situation, I've actually looked at a contract, for example, where there was a limitation on acts of God which ends with a state of emergency.
That
does not cover a national disaster.
Aha, now we're getting technical.
You understand? So we're not in a state of emergency. So is this an act of God? And this is the big question.
So the bottom line is you got to get a contract. You got to make sure that your legalities are done up front. Of course, this is an unprecedented situation, but still, you got to have your contracts done up front. Mr. Malatji, let's leave it there. Katlego Malatji, Director Trade, Tailormade Law. And of course, you can hook up with him on Twitter and make sure that you get his details in case you need some help on your own contracts.